David Henderson now, civil rights attorney, former prosecutor, CNBC contributor. David, let's start with the prosecution. What did you think of their closings, and did they make it all tie together?
Shep, my thoughts about the prosecution's closing are similar to the defense with respect to how long they took. I think in this day and age, a presentation should be 20 to 45 minutes. Talking over an hour, which both sides did, well over that, especially for the defense, is really pushing it with regard to what you should expect jurors to be able to absorb. And here's the thing. Closing arguments aren't actually arguments. They're just a chance for you to tell the jurors that are on your side what they need to do when they go back to deliberations. Both sides could have done a better job with that.
Well, the defense took 2.5 hours. And
that's right.
but you know, I've talked to a number of people who said, you know, one of them about 5 minutes ago, who said, you know, they put a lot out there. There's a lot going on. I guess that was the idea.
I think so, Shep. And here's what you have to remember about the defense. In fact, just look across the country. People are divided over police reform and policing in general. Even after Daunte Wright got shot in Minnesota, you had the thin blue line sign flying up at police headquarters. That tells you that a lot of people will accept some of the arguments that Nelson was making. And so he's not trying to make a reasonable argument. He's trying to appeal to a potential unreasonable person on the jury that might hang up any conviction for Derek Chauvin. And I agree. He put a lot out there.
Chauvin faces 3 different charges: murder in second, murder in the third degree, and second-degree manslaughter. When a jury's about to deliberate multiple charges, could that be overwhelming for them, or is the idea on the prosecution's part to give them a lesser included just in case?
Shep, I think they can actually absolutely be overwhelmed by that process. And that's why I was frustrated with the state's closing argument. Typically, the way a closing argument needs to go is it seesaws back and forth between teaching jurors the law, applying it to the facts, teaching it to them, and applying it to the facts. The reason that's important is because of what you just said. It's confusing. Not only do you have 3 different charges, but they're 3 different charges based on the exact same conduct. So how are you supposed to decide which one to convict on and how? That's part of a closing argument is supposed to answer.
David, thank you. Shepard Smith here. Thanks for watching CNBC on YouTube.